Hi, everyone. Hi, everyone. My name is Melissa Heikkilä. I'm Politico's AI correspondent in London. Today, we're going to talk about the European Commission's AI Act. Joining me today are an excellent panel of speakers. They are Lucilla Scioli, who is a Director for AI and Digital Industry at the European Commission, Dragos Tudorache, who is an MEP and Chair of the European Parliament's Special Committee on AI, as well as Daniel Lofer, who's the EU AI Policy Lead at Access Now, and Cornelia Cutterer from Microsoft, and she is the Senior Director of European Government Affairs, Rule of Law, and Responsible Technology. Hi, all. Before we begin, a quick reminder. Don't forget to submit questions in the Swapcard app, and they will be in the box next to the live stream, and please do answer our poll. Feel free to also tweet about this event with the hashtag Politico AI. Now, why don't we start with you, Lucilla? The European AI Act creates a product safety framework with some prohibitions. Why did you choose this approach, and what are the kind of two main things people should remember about the regulation?
The main thing people should remind about the regulation is the fact that we are not regulating artificial intelligence technology, but we are regulating the use of AI systems in certain contexts, and that we come up with a list of use cases that we would like to be checked before they are put on the European market. We also, and I want people to remember that most of the artificial intelligence market will actually not be regulated. So we have some high-risk use cases that, as you said, will follow a sort of CE marking approach, and they will be checked before they're put in the market with some controls once they're in the market. And then we introduce some transparency requirements for some other applications like chatbots, deepfakes, emotional recognition systems, so that people know what and who they're dealing with. And finally, we also include some prohibition, very limited for certain applications we think that are not acceptable in the European Union, like social scoring.
Great, thank you. Now, this framework sets quite a lot of obligations for tech providers. Cornelia, what do you think? Is this a good approach, or what did you find lacking?
Thanks, Melissa. Thanks, first of all, for having me here on this panel. And very concretely to your question, I think the Commission did a great job in parsing out what is high risk or what should be banned. And we support this approach of focusing on high risk scenarios, regulating scenarios, use cases, rather than AI technology as such, which is already regulated, and any existing law would apply to those technologies and use, of course, as well. What is interesting, though, in this context, and you mentioned as a provider of the AI, most of the focus is on the providers. And the Commission has made a parallel between AI, standalone AI systems and product safety. And this is where eventually we need to think a little bit through what this really means in applying the construct of product safety to AI systems. So, because down the road, there will be questions then that arise. For example, does the focus on data quality or error-free data achieve all objectives, such as fairness? And this is where socio-technical aspects will play a role in assessing those. I'll stop here. There is other follow-through questions coming from the design approach the Commission has chosen, but I'm pretty sure we'll get to those as well.
Great, thank you. Now, Daniel, civil society campaigned really hard to get clear, explicit bans on certain technologies, such as facial recognition. And the EU AI Act has some prohibitions for remote biometric recognition systems in public places by law enforcement, but comes with a lot of exceptions. Now, was this a disappointment for you?
Yeah, again, just to say first, thanks for having me here. Great to be part of the discussion. It certainly was. I mean, I think it's really important that there is a section on prohibitions. I think that sends a clear message that there are certain applications of AI that are simply incompatible with fundamental rights. Unfortunately, what's in the section on prohibitions is actually quite weak, and is in particular the prohibition, if you want to call it that, on remote biometric identification in public spaces by law enforcement falls far short of what we've been demanding with Access Now, and we're a member of the Reclaim Your Face coalition. We think the exceptions are far too broad. They provide far too much leeway, and the focus only on law enforcement is problematic. And I think one important thing to highlight is that there's no treatment of the problem of establishing the infrastructure for this technology. If you look at the current prohibition, it seems that what you would have is, complete leeway for the installation of cameras, for the purchasing of the technology, and you're just regulating when the switch can be turned on and off, which is highly problematic. We think that this infrastructure should never be installed in our public spaces, because the possibility of effective oversight of when it's used and when it's not used is just not going to be enough to protect fundamental rights. We really need to stop this technology from being installed, not only from being turned on. And we also need to look, I think, more fundamentally at what kind of research we're incentivizing, whether that's through something like Horizon Europe. We need to not be developing technologies that fundamentally are designed to surveil our populations.
Great. Now, Lucilla, I'd like a reaction from you to Daniel's criticism, because previous leaked versions of the AI Act had a clear ban on mass surveillance, but that's been watered down in the final proposal. What happened?
Look, as I said at the beginning, I think it is important to keep in mind that this is an act on regulating the use of AI in certain contexts. So we're not regulating whether you can put up cameras or not. We are really regulating whether artificial intelligence systems can be used to examine, for example, the footage from those cameras and identify a watch list. So this is really what is in the area of regulation. Only for law enforcement authorities, that's what it looks like, because for the private use of remote biometric identification, the General Data Protection Regulation is already dealing with that. And so we didn't want to repeat what is already regulated in the European Union. Where we thought there was a bit of a gap was for the law enforcement authorities. And I don't think that the exceptions are very, very large, because the exceptions are about the fact that this system can be used by law enforcement authorities in the presence basically of a serious crime, and the list of crimes is listed in the European warrant. So what we propose is that, first of all, member states have to have a national law that allows them to use remote biometric identification in public spaces by law enforcement authorities in the list of crimes that we propose, or in a subset of this list. Member states can always restrict it if they wish to do so. And the law enforcement authority will also need to have a judicial authorization to be able to use it. So it's not really, we don't make it very, very easy actually to be used, but we think it's necessary when there is a serious crime, when there is a threat of a terrorist attack, when we're really, in the presence of something where the police needs to use this technology to find and put us in a safety situation.
Great, thank you. Now I'd like to go to you, Dragos. Before the AI Act becomes law, it has to pass through the EU legislative machine, and it's probably going to face a lot of intense scrutiny at the European Parliament. I mean, what's your take? What are the main political tensions going to be in Parliament, and what do you foresee being the main sticking points between different political groups?
First of all, good morning, Melissa, and good morning to the political team. Thanks for having me. Indeed, we've heard the Commission representative say how the Commission has done its job, and it's true, they have done their part of the bargain. Now it's time for the European Parliament, for the legislators and the co-legislators in Council to do theirs. It's certainly going to be a complex and long process, there's no doubt about it, one that will be shared between various committees in Parliament, depending on the type of issues that we'll be dealing with. What will be the main lines of the, let's say, political battleground? Well, I think first will be on the clarity of language. I've heard as part of the many conversations on AI here in Parliament, not only in the committee that I chair, EDA, but also in all sorts of other related events, I hear a lot of discussion already on the clarity of the definitions in the text. Starting from the type of applications, use cases that are being prohibited, the 4 categories, but also in the way some of the use cases in the high-risk list in Annex 3 of the text are being defined. It's true there is some flexibility in the text of the regulation to allow for the adaptation of these definitions over time, which is not a bad thing, a bad technique. But again, this will be one of the main work sites at the legislative level to try, at least that would be the attempt on our side, to try and bring as much clarity as we can to these definitions. The second one, and it was already mentioned earlier in the previous conversation, which is about the facial recognition biometric, remote biometric recognition as it is being defined in the text. Because this was one of the long debates here in Parliament. There are political groups which have been asking for quite some time for a total ban on the use of such technologies in public spaces, and for what is being broadly defined as mass surveillance. And I think the text comes with this possibility for law enforcement to use this technology, which I've heard other groups supporting. So I think this will be a big discussion that we'll have, and it remains to be seen how the different political groups will be positioning on this. But certainly it won't be a conversation where there will be a clear winner or a clear majority being formed. Maybe last, as an introduction, last point, which I think will stir a lot of the debate, will be around the balance between achieving what the text aims to achieve, which is providing a human-centric evolution of this technology with the element of trust being put at the heart of the conversation, and at the same time, ensuring the right stimulus, the right boost given to our businesses to grow, innovate, research in this very important piece of technology. And again, here, I can already feel divergence of views between the various political groups, with some believing that that is already there, that is enough, and then other groups feeling that the balance is not yet fully achieved in the text, and that we need to actually do more. If we also look at what other global partners around the world are doing in terms of encouraging these technologies, that somewhat beyond achieving the objective of regulating, putting the right framework around the evolution of the technology, we also need to come at the same time, maybe in the same text, and boost the idea of innovation more. There are the sandboxing, the sandboxing, let's say, option is there in the text, and that's already a good thing. But I would have, I might add a personal touch to this as well. For example, I would have liked to see a bit more on sandboxing, a little bit more in providing this safe space for trial and error in the development of such a cutting-edge technology, where the startups, the ones developing AI, can actually safely engage with authorities, whether data protection authorities, whether regulators, to make sure that the technology that they evolved from the very beginning is going in the right direction. So, as a first intro, these are the feelings and the positioning here in Parliament. Of course, there are there are many parts, other parts of the conversation on AI diplomacy and so on and so forth, but I'm trusting that we will have a chance to go through that in our conversation.
Excellent, thank you. Now, Cornelia, do you think this legislation strikes the right balance between innovation and also protecting citizens' rights?
It's a good question. I think currently we will still have to parse through what it means, the requirements for providers. I think I'd first like to focus on, does it actually achieve the objectives to protect fundamental rights? And as I mentioned earlier, it is focused on a product safety type of market surveillance. What is missing here is eventually the transparency in the specific uses. So the provider will have to define the intended use based on which he will provide the information to the user. But there are gazillions of potential uses, in particular where you have a foundational AI systems, and there is no comprehensive transparency for the citizens to then be able to see when those AI systems are used. So while we have a database with where the providers are obliged to insert their AI systems, there is no such requirement for the users closer to the citizens, like the banks, the schools, the police. And that would probably help the citizens in the context of those fundamental rights. At the same time, because the focus is on the providers, it will put significant burdens on the providers to fulfill both risk assessments and quality assessments, and in particular, a post-market monitoring system that needs to be put in place. So that's quite a large burden on the providers. And there is a question, in particular for small SMEs, that whether that is a feasible way and whether that will spur innovation. So there is a bit of both sides question mark in the context, in particular on systems that are standalone, that are not embedded in products where safety legislation applies, whether this is indeed the right way to approach this. And I think if we rethink that structure slightly, it might actually also help Dragos's point in increasing the innovation cycle and not hindering innovation.
Great. And where do you stand on bans?
So the Commission has put forward, I think, the right way to parse through this difficult question. We have always stated that there are technologies that either are not ripe for use yet or shouldn't be used in certain circumstances because they are a risk to fundamental rights. So we support the approach generally that the Commission has taken on facial recognition specifically, because that is probably the one where Microsoft has been quite outspoken. We have, as early as 2018, started to advocate for facial recognition technologies and the use of those to be regulated. Even where many said it could all be done through GDPR. Now, it seems to me that the Commission has taken an approach that aligns to how the rule of law is set up, considering scenarios in which it might be proportionate and necessary to use those technologies by public authorities in public spaces, but the ultimate decision on those to carve them out, I think has to now be done by the legislators. What we would say, however, in this context is that you could probably improve those provisions by imposing some sort of transparency reporting on the police that would use those, so that there is more accountability on such use exemptions.
Great. Does Microsoft sell facial recognition software to law enforcement agencies in Europe?
So we, in every country that we do business, our approach is governed by our facial recognition principles that we have published end of 2018, providing more specification to our ethical principles. So the process in how we stand to facial recognition technologies is determined in this context. In the US, for example, we've made the decision not to sell facial recognition technology to US police departments until there is a strong law grounded in human rights. And our engagement with law enforcement generally is governed by our sensitive use process. So which is a review and oversight process led by our Office of Responsible AI to ensure that high impact cases align with our principles.
Great, thank you. Now, Daniel, you said that the proposal's approach to biometric categorization systems is deeply concerning. Why is that?
Yeah, this is really one of the most shocking things that I encountered when looking at the proposal, and I can just read it out for you. There's a definition in Article 235, and it says a biometric categorization system means an AI system for assigning natural persons to specific categories on the basis of their biometric data, okay? And then it lists some of those categories: sex, age, hair color, eye color, tattoos, ethnic origin, or sexual or political orientation. Now, this is actually a crazy definition, because some of those categories are defined by biometric data, like hair color. You can perfectly well have a machine learning system assign people to hair color categories based on observable biometric data. You can't do that with political orientation unless you happen to ascribe to really problematic theories of physiognomy, where you relate the length of people's nose to political affiliation or something like this. And for us, actually, that's maybe the clearest thing that should be banned. We've advocated for bans on emotion recognition, on gender recognition, which inherently discriminates against trans and non-binary people and undermines people's rights to self-determination of gender identity. But I think on a more general level, if you're inferring sensitive characteristics or complex aspects of people's personality from observable biometric data using machine learning, you're doing something that you really shouldn't be doing. I think there's, that's sort of a no-brainer for a prohibition. And all that currently happens in the current regulation is that you have to notify someone that you've, determined their sexual orientation by the shape of their face. So that's deeply, deeply problematic. And I think on a general level, there are certain things, not only in this kind of what people have been calling the medium risk category, but also in some of the high risk categories, the use of AI polygraph techniques. This is also scientifically baseless and deeply, deeply problematic from a fundamental rights perspective. There's no good evidence, no strong scientific basis for polygraphs as we have them today. And simply slapping machine learning on top of a dubious scientific practice doesn't make it better, and probably makes it significantly worse. So from our perspective, there's so much of the stuff that we were advocating for, on very good grounds for prohibitions, has either ended up just in the high risk, and so is essentially just has to go through self-assessment conformity procedure, or in the case of the biometric categorization, is just as this very weak transparency notification towards affected persons.
Great. AI systems that claim to be able to read people's religion or political orientation, I can't really see that going down well in places like Germany. Now, Lucilla, why didn't those systems make it into the ban list?
Well, if I remember correctly, categorization is one of the sensitive areas we have recognized for the high-risk systems. So if we have evidence of, of an application that is actually working that way, then we can always adapt our legal act to this case. I think that for the moment we did not really have sufficient evidence for that. So, but we have kept the opportunity of doing so. Now, every time we say that a machine learning system or an artificial intelligence system does not work very well, we said it for facial recognition, we say it also for probably examples of categorization. Well, this is exactly why we also have this ex-ante system. So if the system doesn't work well, then it will not be allowed to be put on the market.
Great. Now, Dragos, I'd like to talk about maybe the next steps. How the Commission's idea here is to create a kind of global standard, and in your work at the Parliament's Special Committee for AI, you've talked a lot to members of the U.S. Congress. What's your take? How will this be received internationally?
Well, a lot of people are trying to draw parallelism with GDPR and with the way GDPR has been received or rolled out, let's say, as a standard worldwide, and also many I've heard trying to anticipate some sort of resistance across the Atlantic. I actually don't think and haven't felt that resistance. And in fact, I think that also if we do things rightly on our side, and if we don't have the arrogance as European Union of somewhat bestowing upon the world this new set of standards that we've put in place, and in fact, we use them to properly reach out as content that is already on the table, as work that has already been done by us at the European Union level, but understanding that somewhat when we discuss about global standards, we need to talk to the others. I think then the work ahead is going to be a positive one. You've mentioned our transatlantic partners. Indeed, since the creation of AIDA, we've been reaching out to them. I've had contacts with many that have the lead on AI and generally on cutting-edge technologies in Congress. In fact, this week, 3 days from now, we are going to have the first, let's say, structured dialogue, structured meeting between AIDA committee and what is called the AI caucus in the US Congress, which is the grouping that brings together all of the members that representatives, congressmen, and women who are and have been working on AI for the last few years. There is a lot of commonality in the work that is done. There is a lot of commonality on how we understand the risks, how we understand also opportunities, on the whole issue of ethics, of where we want to set boundaries from an ethical point of view. Again, I have felt there is a lot of common ground that I think we now need to explore. The Commission has suggested creating or putting together this as part of the TTC, also creating a dedicated transatlantic AI agreement, which I think is a good thing. I know, again, that the Americans are also looking forward to set up this sort of alliance of digital democracies, as they like to call it. I think labels aside, it is essential that we engage as quickly as possible, both at an executive level, which is work that the Commission will do with the governments of member states and the US administration, but very importantly also at parliamentary level in a bipartisan fashion. Here, I feel that on this issue, there's quite a strong majority in European Parliament across the political groups to engage in this sort of dialogue with the US. Also on their side, I feel there is bipartisan support for this approach. So I am starting this dialogue, this reach out, this sort of AI diplomacy with a positive thought. We'll see after this week's meeting what kind of a calendar of further engagements we will agree upon. It's something that we want to do already at this first hearing, at this first meeting. So again, all in all, I'm positive we can set this in motion. Then once we do, what I think will be very important, and also this touches upon what I was saying earlier about the level of ambition which I feel we should also have at European level. I think we need to also go past the conversation on setting norms, which is very important, of course. But our cooperation should not only be about that. It should also be a cooperation where we identify together very concrete projects that we can work upon. Points of common research and innovation that we can agree upon. We need to also encourage, support, fund networks of researchers that are working on this side and the other side of the Atlantic. Again, we need to invest in artificial intelligence. If we want this technology, again, to be the driving force for the digital transformation in Europe and the world, and to be that in a positive way, again, beyond regulation, we also need to properly support it. And I think that certainly on the US side, there is an approach that they have, I would dare say, a better tradition of rolling out than we do. And I think this is where we can mutually support, educate ourselves, educate each other, and support and set this as common objectives.
Great, thank you. Before we have a few minutes left, and I want to take a few audience questions. Now, here's one for you, Lucilla, following up on what you said before. Vanya Skorik is asking, what does it mean if the system does not work well, it will not be put on the market? Work well for whom, and based on what assessment criteria? Are human rights and fundamental freedoms from the EU Charter included?
So it doesn't work well means that basically the requirements that we have introduced for the checks that should be made before the system is put on the market are not met. So this can relate to the quality of the data set, but this can also relate, for example, for certain performance criteria that may relate to the accuracy or the robustness or the cybersecurity of the system. For example, if you take something like biometric identification, there are already some standards which are helpful to kind of compare to the state of the art, let's call it performance of a system. So you could already draw some conclusions about whether a system is performing in a certain way or not. And our proposal is actually designed around the idea and the wish that industry will get together and develop standards against those requirements and obligations, so that it will be even easier both for companies and developers of artificial intelligence to know and to understand much easily and better exactly how to comply with those requirements, as well as for the conformity assessments to be complied with. So I think that the existence of standards which relate very much also to the state of the art of the situation in the different contexts can be really, really useful to the implementation of this legislation in the future.
Thank you. And another one from Peter Lloyd. He's asking, what provision is proposed for individuals to check on the correctness of public face recognition data? Will people be notified whenever their places are being scanned in particular places, especially unexpected places?
I don't think we have introduced a provision in this sense. I will have to check, and I will have to come back to you, because here it's an important detail, but I need to check it with the colleagues.
Okay. Great. Well, another one. People, I love it. Keep the questions coming. We have 3 more minutes. So, Lucilla, a bit more. One more question for you. Will the Commission be able to decide that third country legislation on AI is adequate to the AI regulation?
Well, the Commission will decide that if, for example, third countries organize conformity assessments which are in line with the ones that are organized at European level. In that case, we would say, for example, that they have an adequate system compared to the European Union, and therefore, if adequacy is met, the providers coming from those countries will have to carry out their ex-ante checks in their home country, and then they would be able to introduce their systems in the European market. Now, this is not the case for the moment. We don't have any, as far as we know, conformity assessment that would check the kind of obligations that we propose in other non-European countries. So, but this is the concept of adequacy. If they can organize themselves and put in place rules that are similar to others, then we can say we are in a situation of adequacy, and therefore we would accept their AI systems in our market.
Great. And a question from Leonard van Rompuy, sorry. How do you reconcile a product safety model with a technology that is in part digital, software-based, and has no actual physical product? Apparently software are not considered products in the EU.
So we have we didn't want to make a distinction between those products that are delivered through a service or those products. The same product can be delivered through a software that is embedded in a machine or in a robot or whatever. So we have recognized, let's say, the functional equivalence that some of these services can have. And we have provided for, this is also happening in safety legislation. If you see, for example, the medical devices regulation, which is the most advanced, let's say, or the most updated safety regulation that we have in the European Union at the moment, they will consider software as part of the safety regulation and treat it as a product. So this functional equivalence is recognized. And if what we say is that if there is a conformity assessment already, a third-party conformity assessment already required and already organized in the European Union, then that product or service will have to undertake that process. If that process doesn't exist yet, then we will start with a process of self-assessment. Of course, we have foreseen market surveillance authorities for the monitoring of the system once it's in the market, and we have also foreseen a registry for a database where this documentation and these products can be registered into. So there will be checks, even if we ask for a self-assessment at the beginning. But this is how we have organized the system to work for the products and for the software systems.
Excellent, thank you. Now I have a question for Daniel. In what circumstances is AI with facial recognition acceptable?
Good question. I think when it comes down to it being used in publicly accessible spaces, none. It's completely, from our perspective, disproportionate. It can never be necessary and proportionate in given situations. It creates just far too many risks for function creep. So it cannot be used in publicly accessible spaces without enabling mass surveillance and discriminatory targeted surveillance of marginalized communities, for example. I think what needs to happen is the onus needs to shift from the current model where you've basically got systems being rolled out, and then we have to find out about them, whether investigative journalists, people who are affected by them, civil society organizations, make a complaint to the Data Protection Authority, then it turns out, oh, the system is not compliant and it's ordered to be withdrawn. That's the current model, and that needs to flip, where there's a prohibition on the use of these things in publicly accessible spaces. And if someone has good arguments to come forward with for a particular use, then they can come forward and make them, but I haven't heard them yet.
Great. There's a question from Claudia Pretner on emotion recognition technology, which is highly, highly controversial. And she's saying that emotion recognition systems are highly intrusive, inferring sensitive characteristics with high rates of inaccuracy and potential uses ranging from commercial use, recruitment procedures, to law enforcement. And these systems are not included in the ban. So this is for you, Lucilla. How does the Commission see such systems to be compatible with fundamental rights?
Well, as I said, we in principle prohibit them when they are done in real time and in public spaces. So we certainly don't want law enforcement authorities to use these systems and then restrict people's freedom and therefore their fundamental rights and other creating also other issues when these are used in real time. And this is why we say that law enforcement authorities can use them only in certain circumstances, and by the way, in a limited time frame, in a limited space, and this has to be authorized by law and by a dedicated authorization. So I think that we try to frame it as best as we can, because we still think that there are really serious crimes or situations of threats of terrorist attacks where we think that these systems can be very useful for our own safety.
Fantastic. And one more technical question, if you may. Renaud Vedel is asking that the Sandbox scheme is only applicable before putting AI products on the market. Does this mean that the regulation applies before putting on the market? And if so, at what stage does it start to be applicable?
Okay, so the way I see the sandbox is that the sandbox would take place before the good or the service is put on the market, and even before the stage of the conformity assessment. The regulatory sandboxes were introduced in our sandboxes where basically developers can use lawfully collected data to retrain the artificial intelligence system with very specific public interest objectives in controlled environments under the supervision of the data authority. So these are obviously tests that developers are taking place, are experiencing, and so this is not a regulatory sandbox necessarily comes before the conformity assessment comes and before the goods or the services put on the market. I just want to take the opportunity, if you don't mind, to remember that it's not in the legislation because it is not a legislative point, but it's in our Digital Europe program that we are also funding testing and experimentation facilities with the member states for artificial intelligence. And these are new facilities that we will be funding in healthcare, manufacturing, agro-food, and environment and smart cities to make sure that developers have the possibility to test and experiment with their developments. These are not controlled environments. These are a bit different from the regulatory sandboxes, but a very important element for testing and experimentation before, obviously, the goods or the service is placed on the market.
Great. Thank you. Now we have 1 minute left, and I want to hear from all of you very, very quickly. Knowing what you know, what's your bet? When is this AI Act going to be law? Why don't we start by Dragos?
Well, I think at least a year and a half.
Sorry?
At least 1 year and a half.
Oh, 1 year and a half. Excellent. Okay, Cornelia?
I would agree with Dragos. I would assume that the legislative process takes us 1.5 years, and then if the provision stays, it's another 24 months until companies will have to comply.
Okay, excellent. Daniel?
I'm not going to contradict Dragos on this, I think, so it sounds like a reasonable timeline and a doable one from our side, I think.
Excellent. Okay, well, hopefully we won't have a 6-year GDPR negotiation hell this time. Thank you so much, all. This was a fascinating conversation. Yeah, I'm glad to hear we might be having an AI law in sooner than expected. Now, don't miss the next session of the summit, which will provide the perspective of SMEs on the AI legislation. The discussion will begin in a couple of minutes and will be moderated by my colleague Clotilde Gajard. So stay tuned. Thank you all so much.